Hello, Makati. Hello, world. This is Attorney Angel, and I'm your legal angel. Hi, guys. Now, on the seventh week of our ECQ, and with the recent announcement of its extension until May 15, I'm praying that we will be as healthy as we can be. I know it's not easy, but hang in there. I know it's difficult for all of us. I too have my own struggles and I too have my own anxieties. But what I do is I do my best to overcome them. I try my best to fight and also, and most importantly, I pray and thank God that I'm able to survive this crisis day by day. That I'm able to survive, and I'm hopeful and I believe that we can all get through this. Yesterday, I came across with a music video of Alicia Keys, and I hope you check it out. It's entitled "Good Job," and my favorite lines there are these: "Don't get too down. The world needs you now. Know that you matter. You're doing a good job." It's a salute to all our frontliners, a way of giving thanks to them. But I think that it's also for all of us. As she mentions, the fathers, the mothers, the teachers, the preachers, strangers, friends, and more. And that she said that top to bottom, we all matter. So I think this song is also for all of us. In that we can end this, we can fight this as long as we help one another. We are all in this together. And personally, I believe that we can be guardian angels of each other and of one another. We can do this and we can get through this. Okay, so this is the third and last part of the vlog for the Life in Law School series. So we will continue with the tips in reading cases, as well as case digests and general tips. Okay, so let's begin. Okay, we're coming from the last topic on recitation in part 2 of our vlog. And for this part 3, we begin regarding tips on how to answer written questions. You may be required to submit an assignment, a written report, legal opinion, reflection, or reaction paper, and other legal writing requirements in class. Here are some basic tips that you can keep in mind when you are required to answer written questions or when you are required to submit other types of written requirements. Follow the instructions. More often than not, the professor will give you instructions on how to go about the assignment. So rule number 1, Read the instructions first. Well, there are students who skip this first step, and only when they are in the middle or towards the end of the assignment that they will read the instructions. And then they will realize that they did not follow the same, or their written work is not in accord with the prof's instruction. Then they have to revise, amend, modify, or worse, start over again. This will be a waste of time, energy, and effort. So, lesson learned, never skip the instructions. In connection with the first step or the first tip, the professor will usually give a preferred format as to the font style, font size, margins, paper size, number of words or word count, spacing, etc., etc. Never take these for granted because the form counts. Before the professor can read your written work, the first thing that the professor will see and look at is the form or presentation of the written work. It's just like when they say that in the bar exams, the first thing that the bar examiner sees is the form and presentation and the penmanship of the examinee. Let's ask Judge Selma and Vincent, bar examiners in the Berna Bar. Yes, who are our professors also in the UMAC School of Law. They look at these when checking. If it is not pleasing to the eyes, then why bother taking time to read it? So yes, content is important, but form or presentation is just as significant. Keep it simple, write in plain English. In part 2 of the vlog series, I already mentioned about the use of plain English for lawyers and about Brian Garner, a staunch advocate for plain English for lawyers. His book on this is very helpful, and I recommend that you read about plain English for lawyers. There are many sources aside from Brian Garner's book. Again, as I mentioned in part 2, you do not have to be verbose or use legalese and highfalutin words. The simple, the better. Be clear and concise. Use legalese only when necessary. This is also connected to the previous tip. The simpler it is, the clearer it is. Concise for me can be simply put as your work should be long enough to be interesting and short enough to cover everything. Does not need to be very long or novel-like in length. Just as long as you capture everything required for the answer, then you're good. As to legalese and the use of legal jargons, well, there will be times that you cannot avoid it. So you will have no choice but to use the legal jargons, the technical terms, or resort to legalese. But as much as possible, if you can avoid it, if it is possible to avoid it, then please do so. Proof your work, read and reread. Proofread, check your written work. Check the spelling, the grammar, sentence construction, the coherence and organization of thoughts, the substance, the arguments, the reasoning. Check if you followed and used the correct format as provided by the professor, and if you need to edit and refine your work before hitting or clicking the send button or the print button. Sorry. If it is required to be submitted in your own handwriting or penmanship, make sure you don't commit mistakes so you don't have too much erasures. It's a turn off. Also, no liquid eraser, please. No snow pick, no correction tape, no liquid paper. No, 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 no. You can write the draft on scratch papers first before writing the final one. Make sure your work is clean and that your penmanship is legible. Do not give your professor a difficult time in reading and checking your work. Check your citations. This is part of the honor code. Honesty is the best policy. If your idea was borrowed, make sure you acknowledge your source. Plagiarism is a very big no-no. Always, always cite your sources. And practice, practice, practice. Although nobody's perfect, practice makes perfect. Whatever shortcomings, errors, or lapses, when you practice and practice and practice with patience, then you will soon overcome your shortcomings, correct your errors, and make sound judgments in the process. We learn from our mistakes and we avoid committing them again. Okay. Apart from written assignments, written exercises, and other legal writing requirements, you also have to answer quizzes and exams. Okay. There are many variations on the method of answering exams and quizzes. The most well-known method is the IRAC, issue, ruling, analysis, conclusion, and the FIRAC, facts, issue, ruling, analysis, conclusion. Other schools have a spin on it, like, for example, the PUP College of Law, they use the RELAX, or the reply, legal basis, analysis, conclusion system. I also devised my own for my classes in UMaxol, and I named it as CLAC, or CLAC method, which stands for categorical answer, legal basis, application, and conclusion. Okay, so this is applicable if the question calls for a yes or no answer. There are facts given and a problem is asked based on these facts. For example, if a question is asked in legal ethics regarding a certain client who consulted with a lawyer, let's say, for example, the client is named Fina and the lawyer is named Attorney Juris. Then the question at the end is whether or not there was a lawyer-client relationship established between Fina and Attorney Juris. So in this kind of question, it calls for a yes or no answer. The CLAC method will apply. Categorical answer, for example, yes, there is a lawyer-client relationship established between Fina and Attorney Juris. Legal basis, the X paragraph, or the L, cite a provision of law. For example, according to the Code of Professional Responsibility, okay, if you can remember the canons or the rule better, but if not, just state that according to the Code of Professional Responsibility, you cannot state the exact legal provision. Or if it is based on cases or based on a case or Supreme Court decision, then you can also say that based on a recently decided case of the Supreme Court or based on a decision of the Supreme Court, then you state the ruling. Then the next paragraph, the A, the application, which is equivalent to the analysis portion. So you apply the legal provision based on the facts given in the case or in the problem, okay? For example, after stating the legal provision, in this case, Fina, blah, 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 attorney juris, blah, blah, blah. Okay? And for the conclusion, which is the last sentence or last paragraph in the CLAC method, it's merely a restatement of the categorical answer. But for some, they don't advise to have a conclusion or restatement of the categorical answer at the end. But for me, I prefer for reiteration. So the conclusion in my example is that there was a lawyer-client relationship established between Attorney Fina and Attorney Juris and Fina. Period. Okay. However, not all questions will call for the application of this method. There will be questions on definition or enumeration, distinction, comparison, etc. You should check out Attorney Reynulfo Tata Jr.'s Techniques in Answering the Bar. He offers numerous templates on introducing your answers or introductory statements in questions asking you to define, enumerate, distinguish, compare, etc. But the tips on answering bar exam questions require another whole set of presentation altogether. So maybe we can do that in another vlog in the future. Okay. To emphasize and reiterate with respect to written requirements and assignments, and even in answering quizzes, exams, legal writing opinion, legal writing assignments or requirements like opinions, position paper, etc. Always review, recheck, reread, and revise. Okay. So now moving on to the basic tips in reading laws and jurisprudence, then to digesting cases, there is no better way but to read and understand first before memorizing and proceeding to studying the nitty-gritty details. Read, read, and read. First reading, second reading, third reading, until you fully understand and it becomes second nature to you. What I did before was to do the first reading by reading the full text of the case, the kind of reading which was according to the phrasing that I understood. Slowly but surely, I paid attention to every word and detail written. On my second reading, I used the help of my tools, my highlighters, name it, Stabilo, Artline, Dermatograph, etc. What I did before was I color-coded the facts, issue and ruling, and other details I needed to remember. Yellow for the facts, pink for the issue, green for the ruling, and orange for the other relevant details. You can do it your way and make your own color coding. On my third and last reading, because that was what fit my time for study, I just read through the highlighted portions of the case. So it was faster because it was just refreshing in my mind the details of the case, which I already understood and studied. This was my style. You can adopt your own style according to your study plan and the time you can devote to studying. Excuse me. As to reading laws, I essentially follow the same method. I read at least I read the laws at least 2 times before, and then I proceeded to memorizing the assigned provisions. I also highlighted the keywords because these keywords helped me to memorize, and it was easier to remember the provisions because of these keywords. Another hack that I employed was the use of mnemonics, especially if the provisions enumerate elements or requisites, or if the provision is quite long. For example, in the elements or essential requisites of a valid contract, but that's not a long provision. Provided for by the New Civil Code of the Philippines, COC. So consent, object, consideration, in nego, but nego, that's long one. Section 1 of the Negotiable Instruments Law, WPOA. Okay. You can also develop and employ your own hacks to make your life in law school less stressful when it comes to studying provisions of laws and cases. And after memorizing the law, I then went to annotations and explanations in the law books, textbooks, and reviewers. if I had the time. In UMAXOL, the professors are encouraged to assign textbooks since most of the scholars have book stipend for the semester. Case briefing, or more commonly known as case digesting, or case briefs or case digest. Okay. These are necessary aids in law school because it encapsulates and analyzes the mountainous or numerous voluminous mass of material that law students must digest. The case brief or case digest represents a final product after reading a case, rereading it, taking it apart, putting them back together. And in addition to this function, it is used as a tool for self-instruction and referencing. Most professors require the submission of case digests, and I am one of them. The usual format for case digest consists of the facts, the issues, the holding, the ratio. Or sometimes the holding and the ratio are put together. So the facts, the name of the case, parties, what happened factually and procedurally, and the judgment in the lower courts. The issue, the legal problem in dispute, and then the holding, the applied rule of law, and the rationale, reasons for the holding. But for me, in my classes, I devised my own format, the BCSFERF, which stands for badge, caption, syllabi, facts, issue, ruling or ratio, and the follow. Okay. So the badge, this refers to the nature of the case and the keywords. The caption, the title of the case, the name of the parties, the official citation, and the ponente. And then S or syllabi or syllabus, the principles and doctrines cited in the case, the facts, same, narrative facts and procedural facts, the issue or issues, the legal question, and the ruling or ratio given by the court. I usually want this to be verbatim or in the exact words of the Supreme Court because it shows the wisdom of the Supreme Court. And then the folio or the dispositive portion of the case. I am also fond of requiring my students to draw up comparative matrices of cases so it will be easier for them to compare and contrast and distinguish cases with similar facts and issues but different rulings or ratio or the other way around. I think and believe it is a helpful tool. So you must take this seriously. Take case briefing, case digesting seriously because it will also serve as your reviewer in the future. And when you make your case digest or case briefs, please do not make it half-baked or how-shao. Okay? You will suffer in the end. So do it with all your heart, with all your soul, with all your mind. Exert effort. Okay. We now arrived at the last set of slides, the tips in general, which also serves as the summary of everything we discussed in this Life in Law School vlog series, parts 1, 2, and 3. Okay. Read all assigned readings for all the courses or subjects. This is the only way that you can be confident during classes, whether it be recitation under the Socratic method, assignments, surprise quizzes, and more. What you studied comprises your ammunition in the battlefield inside the classroom. Next, take notes while reading. Writing down what you studied in dread will make it easier for you to memorize the lessons you need to study and need to memorize. It can also serve as your reviewer, and it will be easier to go back and read through your notes when midterms come or when it is time for the final exams. Brief, digest cases. Okay, we already explained that earlier. And in connection with taking down notes and digesting cases, it will also be helpful to prepare an outline on the scope or coverage of your lessons per subject. And you can use this as review material before each class. Pay attention in class. Listen, as I emphasize in part 2 of this vlog series. You already know why this is very important. Take down notes. Okay, taking down notes here is different from taking down notes while reading. Here, the taking down of notes refer to taking down of notes during the class. So you will be able to capture whatever questions and discussion your professor covers during the class. And sometimes professors get questions for the exams from the discussions and the lectures in class. Okay. Consider having a study group. This is important. You can't do it alone. As I already mentioned in part 1 of this vlog series, it is important to have someone or to have friends to ask the help of your classmates. Okay? It's important to have a study group. They can also be your support group. There are times that you will find difficulty in understanding the topic or subject matter of the class. Your study group mates may be able to help you on this aspect. And the group discussion will help you understand the lesson in another perspective or point of view, or in a view which you were not able to see at first. Or maybe you had a different understanding and they had the correct understanding. So the study group will be able to help you. In UMACSOL, we have our study buddy cluster system, and we cluster them, we group them into study buddies from first year to the higher years. The study buddies help each other out, they help one another out, and also they become friends in the process. Create a study plan. We also mentioned this in part 1 of the vlog series. Be organized, have a plan, budget your time wisely, study smart. Manage your stress. Managing your stress will be a necessary consequence or result if you follow these tips in general, and even better is if you inject your own strategy of what works or what will work best for you. Only you can answer that, and only you know that. Okay, don't get caught up in the rat race. Okay, we discussed it also in part 1, but just to remind you, sometimes too much focus on the competition or the rat race will bring more harm than good. Just study, be kind, no ulterior motives, share and save up for good karma. Compete only with yourself, but do not be too hard or harsh on yourself. Okay. Ask for help. Everyone needs help. Do not be embarrassed to ask for help. But first, admit to yourself that you need help, that you need others, and you cannot do it alone. No man is an island. I repeat, no man is an island. There is nothing wrong in asking for help. Even if you are the one who will take the bar exam, or it's your own effort when you go inside the classroom during the bar exam, it takes a village to get you there. The admin, the other batches of your law school, your family, your friends, your relatives, the centralized bar ops, the volunteers, the whole community. It's a group effort to make sure that you pass the bar exams and that you fulfill your dream to become a lawyer. Remember that. And of course, be thankful. Be thankful for all their help. Yes, the study of law is work of the heart because it takes not only the mind, the body, but also the heart and the soul for you to survive life in law school. Okay. We've come to the end, the last part of vlog 3 of this Life in Law School series. And I would like to share with you the 7 P's. These are powerful, these are most powerful, this is a most powerful guide for you. I think it can be your personal policy, your pathway to the bar exams, and this will pave the way to your journey into the legal profession as well. Okay. 7 P stand for proficiency, patience, perseverance, planning, preparation, passion, and the last P I will reveal after the 6 P's. Proficiency. It is presumed that when you enter law school, you have advanced skills and knowledge already because this is postgraduate. You are all professionals. You must have adeptness. You must have the savvy, the chops, the know-how before entering law school, and you must make them work while in law school. Uh, for English proficiency, yes, it's very important. Command of the English language is very important because it is the medium of instruction used in law school. And when you become lawyers, pleadings, and when you appear in court during hearings, the English language is used. Patience. Patience, meaning you have the habit or the capacity to be patient. You have tolerance, sufferance, and this is the opposite of having a short temper. Okay? There will be times that you will become impatient because you're not getting what you want, and sometimes you get frustrated because what you worked for, you're not able to reap the desired results. So you have to be patient. It's a work in progress. Perseverance. It is deeper than patience. This is the continued effort to do or achieve your goals despite difficulties, failures, opposition, or setbacks. Okay. Planning. As we said, you have to plan, you have to be organized, you have to be systematic, you have to strategize. Preparation. Preparation is the key. You cannot be a happy-go-lucky student in law school. I don't believe when students say that I did not study. It is not true. You're in law school to study. The purpose of you going to law school is to study the law. So it's not true that you did not study. Okay? I think that's false humility. And you're being dishonest if you say that you do not study. You studied, but maybe that is not good enough, or sometimes you you were not able to cover everything, or that the question asked was not part of what you studied, or you were caught by surprise by the question asked of you by the professor. Passion, the drive, the commitment, the determination, the devotion, the strong desire, which I think is equivalent, bottom line, to love. You have to want it. You have to want it. You have to need it. You have to long for it. You have to love it. You have to love what you are doing. Otherwise, you will not succeed and you will not survive. It must be something that is not dictated upon you or dictated on you. You must want it for yourself, because that's the only way then you will have passion in everything you do. And last but not the least, of course, as I said, the last P is prayer. The power of prayer. You cannot discount the fact that there is indeed divine intervention. Time and again, it has been proven. Personally, of course, for me, every day in law school, prayer helped me. It was my habit of praying before going to class. Before going to class. Okay. And as the Bible says, ask and you will receive, seek and you shall find, knock and the door will be open to you. And if you believe, you will receive whatever you ask for in prayer. So you know the power of prayer. And more than ever in this time of crisis, prayer is our best defense. This is only, this is where we can go to. We can go anywhere. We have to have faith in God and believe in God that He has the power to end this. Okay? So, with that being said, thank you very much. And I hope you learned something from our vlog, Life in Law School series, parts 1, 2, and 3. Thank you for watching. Thank you for listening. And I hope I inspired some of you to enter law school and become lawyers because we need lawyers. Lawyers are still relevant. Enjoy life in law school for those who are in law school. To my students also, enjoy life in law school. And for those who are interested, let me just invite you to apply. To the UMAC School of Law, we have 50 slots available for full scholarship. Full scholarship benefits include free tuition, free miscellaneous fees, 10,000 monthly stipend, 10,000 book allowance per semester, and many more. So I hope that this crisis will end soon, and please stay safe and healthy. Stay at home, bond with your families, okay? And do not forget to glorify God with a grateful heart. Good luck and God bless. This is Attorney Angel, and I'm your legal angel.